Oh my
Okay,
gosh.
whoever is here or back from the other stream, you can see the issues of giving Nate admin rights to a stream. But I was going to clip it anyway. I guess that makes it pretty easy to clip.
Stupid question. Did we think about setting a redirect from that clip to this one?
How would I do it? It was already done.
That's a good point.
I mean, if I was
psychic and I knew that the stream was going to end, then I definitely would have set up a redirect for the stream that in. Anyway, yes.
Wow. So that was the deep state that shut that down, not Nate.
That was a very, very deep state. Oh my goodness, that is too funny.
That was really good.
That was a great start. I hope everybody enjoyed part 1 of the stream. Oh shoot! By the way, this is not on Rumble. Sorry, Rumble. God, I guess I'll upload to Rumble later. Well then,
Deep Nate. Yeah, I like that one.
Deep Nate. Well, we are going to move on to Southern law, and let's talk about the whole. Was it crazy ass letter between Roberta Laundrie and Brian Laundrie, and what the hell's going on?
Yeah, so maybe I'll set the stage a little bit from the legal side of it. The letter would be kind of what it is. So her parents sued his parents for intentional infliction of emotional distress, saying that his parents caused them or recklessly caused them emotional distress in the way they handled communicating after the disappearance of Gabby. So the actionable piece of that really is just the public statement that was released, and the part of it that is allowing their lawsuit to go forward is just this. The quote, "It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family." So they're saying that at that time, the parents knew she'd been murdered, knew the location, and the nature of that statement was to cause false hope in the parents of Gabby that she was still alive. So that was tested earlier in the case in a motion to dismiss, which isn't a test of evidence. It's just a test of the pleading. And the first judge to look at it said that statement in that context could be extreme and outrageous, which would let the case move forward for intentional infliction of emotional distress. It doesn't mean that they proved any of that. Doesn't mean that it would be found to have caused damage, but the judge early on would not dismiss it. So case continues. They ended up adding the lawyer in because it was actually the Laundrie's lawyer who put the statement out there, and he's moved to dismiss the case. And they have too, again, since it's been amended, and that's under advisement. But I think what got this thing back in the news, Eric, that we were talking about earlier, is this letter, which was the subject of a discovery fight that the mother had written to the son that said burn after reading on it. And it had things in it like, if you go to jail, I'll bake a cake with a file in it. If you need to dispose of a body, I'll come with garbage bags and a shovel. Just the normal things that your mom would say to you, when she's communicating. And so that, the Laundrie parent said, hey, they shouldn't have this because it looks really bad. I sent it before the murder, so it clearly doesn't have anything to do with whether I knew about the murder at the time we made this other statement. But the Petitos say, look, this is discovery, and discovery is supposed to be a pretty broad process. We don't have to take your word for when you say you wrote it or whether you were serious or joking or whatever. And, it's hard to get things suppressed in discovery, so I'm not surprised they get this letter. I think the chain of events suggests strongly that they knew that she was dead way before they did issue the statement. Whether that supports their lawsuit or not, is a different story. The fact pattern, as alleged by the Petitos parents, is that Gabby was murdered on or about 27 August. And then on the 29th of August, while he's still out there, they start talking to a lawyer. So they've talked to him. Now they're talking to a lawyer. 1st of September, he gets back. Lawyer's on retainer on the 2nd. And remember, nothing's out in the public at this point. And then they block Gabby's mother, so they don't have to talk to her, and then they issue the statement out on the 13th. So that suggests that they probably knew what happened with Gabby, or something bad had happened to her. It's still, in my opinion, a close call legally whether this letter and that blurb in it really will sustain an entire lawsuit over intentional infliction of emotional distress. But the letter is not one that I ever got from my mom, I'll have to say.
Yeah, we did a statement analysis on it yesterday. Eric Hunley channel, if you want to check it out, with Gavin Stone. And a lot of people were talking about, the buzz was like it was written after she was missing. But if you really read the letter, I think it's apparent that it is true, as the mother claims, that this letter is written before they left on their trip. It's still a weird letter, but the way she was saying the whole demonstration of, look how much I love you more than anything. And it sounds almost like a lovesick teenager talking to her son, which is really creepy. But it was in a present time. And then it was kind of saying that the other may not love him because of actions. And that would imply, in my opinion, that it would be Gabby Petito. Gabby Petito was alive while that was written. So it probably was prior to their taking that final trip. But I don't know. I'm going to go pick on Hayden. What do you think of the letter, or have you?
Sorry, I was in the middle of retweeting.
Yes, please retweet.
I haven't followed the Petito stuff very closely, to be perfectly honest. I'm more of the guy that, follows the stuff about a guy switching with a dog during a DUI sort of thing, and those sorts of weird legal stuff. I try to steer clear of the mainstream stuff that everyone else is covering. So, look, the letter itself to me does scream intent, frankly, in terms of the timing, in terms of what was actually written about and that sort of thing. I'm sort of just brushing up on it myself, but it doesn't look good from my perspective. And the whole burn after reading aspect of it seems a little bit bad form, frankly.
No, I agree, but then that's part of it too. If you're going to be sending something to someone, would you write on that burn after reading?
Well,
or
that was part of the argument that they liked the Brad Pitt movie and the book Burn After Writing, or whatever the hell it was called. But I mean, best case, it looks extraordinarily bad.
Sure.
Worst case, it either shows, if it was after the fact, that they knew what happened, or even worse, if it was before the fact and they knew what he was planning on doing. That's a really lose and incredibly lose situation.
And she's entitled. I agree with Jeff. She's entitled to try and rebut that. What she was trying to do was prevent them from even having the chance to make the argument that Jeff just outlined, and that was a loser. They're entitled to make the argument that was just put out there. And then the Laundrie parents, if they have things to rebut that, they can do that. But it's very fair for Gabby's parents to have access to that letter. There's no way that you shouldn't be able to probe that to see whether it's relevant to their state of mind at the times that are material to the case.
Oh, absolutely.
Sure. But I'm just saying that I guess my big question is it really probative in any way?
We don't know yet, right? I mean, it depends. If it was written after she was missing, to me, it does suggest one could look at that and the chain of circumstances and say, she's trying to convince her son, look, we'll get through this together. There's nothing so bad that I won't love you. And she's choosing to communicate it at that time because she knows what he has done. That's the Petito's argument, right? Now, they can rebut that, but I think that's a fair argument to put forward.
And that's why I would argue it's even worse if it was written before, because that sort of indicates the intent that she knew it was out. However you get out of this, I'm going to stand by you.
Yeah.
At very best, it just looks really horrible. At very best.
Yeah.
But that, by the way, though, that implication, that's strong, as if to say that it was a premeditative letter, like before they even went, everybody's still alive. I don't ever want to read into it to say that, it kind of looks like before they even left that mom said. And by the way, on statement analysis, the bring and then show up cross out it's a weird one, because bring would imply you know where you're going. Show up implies that you don't. But then that would be some amazingly freakish premeditation. And I would never, ever personally want to make that kind of claim. But on that note, I was just DMing with Steve earlier, and I am kind of concerned about people trying to drag families into situations, and it makes me think of the Ethan Crumbley parents case.
Mhm.
And I'm curious to what you think about this, because you have a teenager, kid, obviously, who committed the worst of possible crimes in a school, but you have the scenario where that kid literally documented, I am a creep, essentially saying, I'm going to do very dark things. The teacher saw these drawings, this whole picture, and sent him to the office because he's implying something bad is going to happen. He drew it, all that. He goes into the office. He's in the office, I believe, with the principal, other people, and the parents.
Mhm.
Also in that office was his backpack. Within that backpack was the gun that was used to ultimately carry out the horrible event that occurred later on. Now, here's my problem with this. They're trying to try the parents who demanded that he get sent back to class that afternoon. But when they're trying the parents, are they not overlooking the school administrators who allowed him to be sent back to class, who never bothered searching his bag, who never thought to call the freaking police because a threat was made? What are your opinions on this?
Well, I can tell you I don't agree with you. If you want to know why, I'll tell you.
Oh, yeah, please.
So coming off the Laundrie case, of course, that one is a case where they're suing the parents for emotional distress for what happened after their son's criminal act.
Okay.
And in the Crumbley case, you have a situation where they're being held to criminal trial for involuntary manslaughter under the theory that they were criminally negligent, okay, in events that led up to the son's criminal act. So that's a big difference. And normally in a case like that, when you have a third party, the son, who commits an intentional criminal act, that's called a superseding cause. So even if you did some stupid things along the way, if somebody sweeps in and does a criminal act, the law is going to say, nah, we're not going to hold you responsible for that, Eric, kind of what your point is. Mm-hmm. Now, just because maybe the school didn't do what they should have done, and they probably didn't, that's like, why'd you pull me over, officer, for speeding? Those other people were speeding too. So I think you have to assess the parent's case on the merits of the law, but it is right at the ragged edge of what the law will allow. At the Michigan Court of Appeals, when they finally issued their decision, they said, this case is unique. This case does not set precedent for other situations, and it's based on a totality of things that the parents did. Now, the fact they said it's unique so many times is a signal that they're kind of are departing from the general rule. And so his lawyers have announced they're appealing to the Michigan Supreme Court to try and say that the Court of Appeals is outside the normal law here. But the Court of Appeals said, listen, the checking the backpack, the Court of Appeals even acknowledged that in their opinion, that the school didn't check it either. And I'm not saying someone else should or shouldn't be charged, but what they said was different than the school. The parents bought the gun for him. They left it unsecured. They left the ammo out, and they did it when they knew he was hallucinating. He had told his mother he was seeing demons. He was seeing things flying around the house, and he still left this gun out there unsecured. They told him to suck it up. And then they told him, when they found out that he was looking at ammo at school, the mom said, well, did you show him a picture of your gun? And he said, no, of course not. No, my God, no. So then at the school, with the school not knowing that he had his own handgun, they told the parents what they knew, which is he was watching a shooting video and he drew this picture of all this stuff. And you need to take him home. And the counselor said that's the first time they haven't. So I don't think that lets the school off the hook for whatever responsibility they may have. Yeah. But it's a set of facts that looks very terrible for the parents. Now, it's so at the edge of what the law would let you prosecute for that the Court of Appeals said, as I said, this is a unique case. It's not precedent setting. And that means because they know that, this is just really outrageous and we're going to let this go forward. We don't want this opening a floodgate, because they were very clear. Parents are not generally responsible for the criminal acts of their kids, and you're not generally responsible for the criminal acts of other people. But they said there is an exception. If you do so much stuff that it's reasonably foreseeable that this person is going to commit a criminal act, and in this case, because of the kid having all the mental issues and the gun left where he could get it, I think the combination of all those things make this case for them. Now, I can see somebody agreeing or disagreeing with their conclusion on it, but it's it's a way different situation than some of these other cases, just from a legal thought process standpoint.
Well, the fact you're making an exception
Yes.
tells me that it's punitive. I'm pissed at these parents. So we're going to single them out and say, yeah, well, you know what? We wouldn't do it for anybody else, but we will for you.
But
We
they
don't
also
like
charged the mother in Virginia whose child took the gun to school, not just for safe storage law, which would be a different situation. They didn't have that in Michigan, but also for endangering a child. So they have done it in two places, because when I made a video.
What's that case? I don't know that case.
So first of all, people were like, well, why can't Darrell Brooks' mother be charged for giving him the truck? And I explained proximate cause. And then they're like, well, how come those people are getting charged in Michigan then? Well, first of all, it's a different state and the law's different stuff. But that's why I looked at the Crumbley case and how they could be charged. And in theory, if you wanted to charge Brooks' mother, you could use the same logic. And then they're like, well, how come they're not charging the Virginia case? That's because that's where the kid took the gun into school and shot the teacher. She lived. But of course, a lot of people were like, kind of like this bike thing. They're going, you know, why they're not charging Brooks' mom and the woman in Virginia? Because they're black, and they're charging the Crumbleys because they're white. But nobody came back to the comments later to note the fact that the lady in Virginia was charged with child endangerment and failing to safe store the weapon. So they have done the same thing in Virginia, kind of that they've done in Michigan as well. And
Can
Brooks'
I point
case
out?
is different.
I don't think the Brooks case should be in there, because allowing somebody to drive a vehicle which can be used as a weapon, but that's not its primary purpose.
Yeah,
versus a gun, which its primary purpose is to fire a bullet into something.
The difference being that Brooks,
killing,
the difference being that Brooks ran over his girlfriend, and then the mother still let him get the truck again. So he showed a mindset of using the vehicle as a weapon. Having said that, I pretty much agree with what you're saying, but I see why people are mad about it.
Well, I'm mad at Brooks, period. I mean, I think, I almost wish they had capital punishment for what he did. It's beyond disturbing. That's all him. But I'm just sitting there thinking, just on the baseline, that allowing somebody to have a vehicle which does have other purposes.
Yes, I agree. Yeah.
So I don't know. You guys are awfully silent. What is this? The left side of the screen talks and you guys duck. So
I completely agree with everything. I mean,
I know it's odd to hear lawyers not talking, particularly because we can find anything to argue about any time we really want to. But again, there's not really a damn thing there that Steve said that I disagree with in terms of this. Particularly with the teacher case. I've been following that one myself, and frankly, I think the mother needed to be charged with that, because look, we know that was a kid that had special needs. That kid usually has one of his parents with him in class. The 1 week that the parents aren't there with him, he shoots his teacher. Like that's, there had to have been more red flags there.
Oh, okay, and that's fair. Now let me go back to the Crumbleys. I guess my issue is that, okay, you're going to charge the parents, but you're completely ignoring the responsibility of the school administration, whose ultimate job is to protect the children. And I don't know. I always hear that, wives don't have to testify against their husbands in court because, they're not necessarily reliable. I don't know what would be the right term, but they're going to tend to.
Well, that means a privileged communication, first of all.
Right. Well, that you can't expect parents to necessarily be reasonable or honest, et cetera, about children. And I am very troubled that the administration is let completely off the hook.
But I don't think they're let completely off the hook, because for this reason, the Court of Appeals said, look, this set of facts for these parents, knowing about the mental stuff, being the people about, if there were any of these left out, we just wouldn't let them be criminally charged. So they're at the ragged edge. And whatever you may say for the school district, and I agree they come in for criticism, they didn't do all the things that the parents are alleged to have done. That they're not proven. It's just whether they can stand trial or not. Now, if you want to be more angry about it, I think from a legal standpoint, it has a good basis. Consider the fact that the lawsuit filed against those people at the school for the civil side, which is different, was basically thrown out at state court because of proximate cause and also because of governmental immunity. So there's an issue of where they're dodging a responsibility, which I think immunity has a place. But the parents, the families of people injured here were really upset that the judge said, look, these guys have governmental immunity for damages. So on the civil side, they are kind of scot-free as compared to the parents.
By the way, I have one more question. Is the school still up?
Good question. I don't know. I thought that one stayed open, but I'm not sure.
Well, because that's relevant too, because you'll find like Sandy Hook and
Yeah.
Uvalde and hell, where Alec Baldwin's father taught that coincidentally they just get torn down and maybe not all the evidence is available or you're not able to get things. So I was just curious if this followed that track.
And speaking of shirking responsibilities, it's time for me to bow out. I got to be on a train in a few hours. I need to get a little bit of shut eye before
No
I
problem.
wake up
Well,
again.
actually, we can wrap up the stream and we'll blame it on Jeff. First, Nate ruins
All
everything.
my fault.
Then Jeff ruins everything. So this will wind up being preordained
fault.
into clips. But Jeff, where can people find you?
Legal Vices. That's me right there.
All right, and I hope you can make it back again.
Well, same bat time, same bat channel next Friday. I'll be here.
And Hayden, where can I find you?
Aussie Overlaw'd on YouTube, Rumble, and occasionally on Locals. I am working on that. But guys, pretty much some point between 3 and 5 p.m. every day, try and do some videos covering pretty much anything that is legal, politics, and I throw in some laughter there. So keep an eye out for the videos next week. On Thursday, Ben Roberts-Smith is up for his defamation judgment. We'll be interested to see what happens there, whether or not it's okay for 3 major newspapers here in Australia to call one of our most decorated soldiers a war criminal, which will be interesting to see get the judgment on that. And yeah, keep an eye out, people.
Awesome.
I feel really bad because
it's just getting close enough anyway. So Steve, where can people find you and your bike?
Southern Law, and if I'm not streaming on that, I am out on the street corner somewhere watching my bike for the 5 minutes I can't use it. You better not get between me and it.
And this is it's shameful because usually we have Joe, Good Logic here, and there's always a meme that I get to cut him off when he's trying to say something funny, but sadly I think Joe is on a Jewish holiday and now we have to end the stream politely with everybody and nobody's cut off. But everyone, thank you so much for coming by. Please consider subscribing if you want to see more streams like this. I do this panel every Friday with whomever shows up, and peace.
Have a good week.